Welcome, everybody, to the House Committee on General and Housing. Today is Wednesday, February 12th, all day. And it is a little after 10 o'clock in the morning, and our first witness is going to be Legislative Counsel Ellen Tchaikovsky, who will be doing a walkthrough of H42, an act relating to the creation of Housing Board of Appeals. After that, at 10:45, we will hear from the landlord. And then in the afternoon, we'll be hearing from several developers about housing production before the floor. So, Ellen, I think it's safe to say you know the committee. And please state your name for the record and give us a walkthrough through H42. Do you need?
Nope.
Okay.
Ellen Tchaikovsky, Office of Legislative Counsel. I was actually going to say I haven't been here yet this year, so I was just going to quickly introduce myself.
Really? I think then we should introduce ourselves to you.
Sure. And so I'm the Legislative Counsel attorney that handles land use as well as energy and climate change. But so on land use, I handle Act 250 and municipal zoning, which is why I'm here on H42.
Let's go around. Actually, why don't you start?
I'm Representative Mary Howard. I represent Rutland District 6.
I'm Debbie Dolgan and I represent St. Johnsbury, Concord and Kirby.
Thank you.
Hi, Tom Charlton, Athens, Chester, Grafton, Winter.
Nice to meet you.
Joe Parsons, I represent the beautiful towns of Newbury, Thompson, and Brock.
Leonora Dodger represents part of Essex Town, part of the city of Essex Junction.
Ashley Barley, I represent the even beautifuler towns of Fairfax and Georgia.
I'm Mark Mahaly and I represent Marshfield, Calais, and the amazing recovering town of Plainfield. So, and I said Calais, Marshfield, and Plainfield.
So I was here last year in this committee and I did do the walkthrough of the Housing Board of Appeals. And so for those of you that were on the committee last year, it is a rerun of 647, but you've had some turnover, so I'll go through it. I don't have it on the screen, but it is posted on your website and it still has it introduced. And so this is about creating a new independent board as a Board of Appeals to hear appeals of zoning decisions about construction of housing.
Can I ask a really quick question?
Yes.
Exact same language as last year's?
Yes.
Okay, thank you.
If anything, there were some typos in last year's that I fixed, but I don't think I made any
Perfect.
substantive changes. So this is actually modeled almost identically from the New Hampshire statute. And so New Hampshire has a Housing Board of Appeals. There was testimony last year, I believe, from some people from New Hampshire that came and spoke to the committee about it. And so there are some phrases in here that are not Vermont legal terms. And I think last year, Judge Zone came and testified that if you do want to work on this, there's a couple of phrases that should conform to the way that we structure things in Vermont. But that's a pretty small thing that we could change easily. So on page 1, section 1, the board is established. So there's established a Housing Board of Appeals to hear appeals of municipal zoning decisions on housing projects. So this is zoning decisions only. It's not Act 250 decisions. And it is only for towns that have municipal zoning, which is only slightly more than half of towns have zoning. And so that is sort of the universe we're talking about.
Do you have an exact number of towns?
I have the number 110 in my head, and I don't know if that, and so for Act 250 purposes, there is a list of towns that have adopted permanent zoning, but there are towns that have adopted either pieces of zoning, so limited zoning or interim zoning. And so it's probably a little bit more than that, technically.
But 110 is a good reference.
Yeah, somewhere maybe closer to 130 because it's slightly more than half. But yeah, slightly more than half is how I think about it.
So does it say that it only applies to towns that have zoning?
Well, this is only hearing appeals of municipal zoning decisions
and or other municipal permits and fees applicable to housing and housing developments. Does that mean, can people appeal a building permit?
I don't,
That's on page 3, line 5.
I don't know.
In other words, all those the other half of the towns that don't have, I'm just trying to figure this out, that don't have zoning. Nonetheless, although I know you can do a lot without a permit,
yes,
you do need permits, building permits. You may have design. I don't know if these towns have design review or other ways that their select board hears a project.
so
Appeals of a zoning administrator, appeals of a building permit or whatever.
the only one I am not entirely sure about is building permit, but so like design review or zoning administrator, those things are all empowered through a town plan, through adopted zoning bylaws, and so, yes. A building permit, I think would also be under that structure, but I'm not entirely sure how some towns structure it, but. So I don't think this is universal. I'm pretty sure this is just for towns that have adopted it effectively. And so if a town doesn't have those processes, regardless of if they have zoning, this would not apply to them.
So they obviously don't have a zoning administrator, if they don't have zoning.
Right.
I'm just wondering in those towns whether someone, if there could protest or otherwise appeal a zoning, a building permit to the select board.
I don't think so, but I think I'm not entirely sure. I don't know if maybe either Department of Housing or VLCT could tell you about how some towns have structured that outside of zoning.
The reason this is important, it kind of goes beyond this bill. But the reason it's important is that we've heard testimony here about the problems that housing developments face in towns where various processes are used to oppose the development. And there are proposals to change how we do appeals. If this only applies to half the towns, that's a significant. In other words, if the other half of the towns have no permits, no processes, it would mean no way to object to housing. So if that's, could you let us know or confirm to us that it's really true that about half the jurisdictions of the state do not have an appeals problem because there's nothing to appeal? Because no permit is needed.
I do feel like someone listening may know the answer to that off the top of their head, but I will look into it.
Thank you.
So still at the bottom of page 1, the board has 3 members. They shall have experience in land use law or housing development or both. And so now I'm on to page 2. At least one member shall be an attorney licensed to practice law in the state of Vermont. And at least one member shall be either a professional engineer or land surveyor. The members of the board shall be full-time employees not engaged in other employment or other duties that will conflict with their duties as members of the board. Terms, the board shall be appointed by the Supreme Court for a term of 5 years and until their successors are appointed and qualified. However, any vacancy shall be filled for the unexpired term. Initial board members shall serve staggered terms of 3, 4, and 5 years. The Supreme Court shall designate one member as the chair. So this is an unusual structure in Vermont. Other states use the Supreme Court to make appointments, but Vermont does not. And so that would be a new duty for them.
If I might ask, there's no mention of a land use planner or a planner.
Right.
Okay.
And again, this is the structure of the New Hampshire board. So they do have one engineer and one attorney on their board. Removal, any member may be removed by the same authority for inefficiency, neglect of duty, or malfeasance in office. And so these are terms that are not typically used in Vermont. This is, again, the New Hampshire language. They shall, before removal, the member shall be furnished a copy of the charges and have an opportunity to be heard in defense. Salary, they shall each receive the annual salary as a superior court judge and compensation for reasonable expenses, including transportation. So that is $168,000 a year in Vermont. I did research that the New Hampshire judges are paid less.
Do you know how much they're paying?
Not off the top of my head. I did look, but it's,
And it would be for every single one of the 3 members.
yes.
Okay, line up, man, right, okay.
Sorry.
No, yes, there's a price tag at the end, because those are, they are full-time positions. Onto page 3. So the board shall have the power to, an authority to hear and affirm, reverse or modify in whole or in part appeals of final decisions of appropriate municipal panels. That is the term of art in, the statutes for however a town structures their zoning. And so it could be there's a few different structures they could use, either the Board of Adjustment or the zoning and there's different ways that towns structure it. And so the generic term is appropriate municipal panel, and that's who issues the permit at the municipal level.
So it could be a zoning administrator.
Yes.
It could be.
Well, so that's not a panel. The zoning administrator is usually the first step, but yeah,
Appeal To
yes.
the select board, right?
Yeah.
Okay.
Or the zoning board, however they've structured it. And it's regarding the questions of housing and housing development. This shall include decisions on municipal zoning permits, subdivisions, variances, and other municipal permits and fees applicable to housing and housing developments. Matters subject to the board's authority may include mixed-use combinations of residential and non-residential uses, which may occur on separate properties, provided such properties are all part of a common scheme of development. In exercising this authority, the board shall have the power to award all remedies available to the Superior Court in similar cases, including permission to develop the proposed housing. After local remedies have been exhausted, an appeal may be brought before the board by the applicant or by any other person aggrieved as defined in 10 VSA 8502. And so at the municipal level, it has to be someone who participated in the hearing on the initial permit. At the municipal level, they have to have participated, and there is a defined list of people who can qualify. And so that's the someone in the adjacent neighborhood or any 20 persons from the town. That's the realm of aggrieved people we're talking about here. There's a couple there's state agencies, there's the direct neighbor, but there's a few other people on that list.
Where is this?
So there's a citation to 8502, that's the environmental court's definition of aggrieved person.
Yeah.
But then also 24 VSA 4465 is the list of interested persons who then become aggrieved persons if they're seeking to appeal.
So that list includes people who wouldn't otherwise have standing, but have standing under that section.
Yes.
So they don't have to be abutters, they don't have to be aggrieved in the usual traditional legal sense.
So for the municipal process, there's a list of interested people who can then become aggrieved. And so, yes, it does include any 20 persons.
Right.
Yeah.
Okay.
Yep. Not necessarily someone who's been directly harmed, but who are claiming harm as an interested person. The municipality shall be a party to the action. If the applicant is not the party initiating the action, then the applicant shall also be automatically an intervener. The board shall have the authority to administer oaths and compel attendance of witnesses. They shall have the power to subpoena and subpoena duces tecum. So subpoena is the power to make someone appear before the board. Duces tecum is to provide stuff. So to bring physical evidence, usually documents. So this is what a normal court has as power. On to page 4. These subpoenas may be served by any person designated in the subpoena to serve it. Any testimony given by a person duly sworn shall be subject to the pains and penalties of perjury. All applications or petitions to the board for which no filing fee has otherwise been specified shall be accompanied by a $250 filing fee. I think I think the Superior Court has gone up to $295. It was $250 for a long time, but I think it's $295 now. So on page 4, subsection F, quorum. In all matters, a majority of the board shall constitute a quorum to transact business. No member shall represent a party or testify as an expert witness or render any professional service for a party or interest before the board. And any member having an interest in subject matter shall be disqualified to act. A quorum of the 3-member board is 2 people. So any 2 of them having a conversation would be business that would need to be in an open meeting. In the event of a disqualification or temporary disability of a member or members of the board shall appoint any temporary board members that shall be necessary. Temporary board members shall serve with respect to a matter until the same has been disposed of by the board. Temporary board members shall have the same qualifications as regular board members. And temporary board members shall be compensated at a rate of $75 per day. That seems a little bit low to me, but this is what the New Hampshire statute says. Also, in other similar boards, the PUC has a jurisdiction to have prior PUC members sit in. They don't usually just have one-off members sit in. And for Act 250, alternate district commission members are appointed in the same manner and appointed in advance. And so this is kind of an unusual provision. Not the biggest issue, but it's a little bit unusual compared to how some of our other boards work. In the event of a vacancy, the appellant may elect to continue without waiting for an appointment of a successor board member. On to page 5, the board shall have any clerical, administrative, and technical staff as necessary. They shall have an office in which records and documents and books shall be kept, with a suitable room in which to hold hearings. So they will need space and staff to do this work. Housing appeals. In matters within its authority, the board shall have concurrent appellate jurisdiction with the Superior Court. So any party seeking to appeal a municipal zoning decision on a housing project shall bring the appeal to the board. So this is actually this is different than what New Hampshire does. New Hampshire has a choice. So anyone can opt to go to the appeals board instead of the court, but this is a requirement saying that the party has to go to the board instead of the court. The decision to bring an appeal before the board shall be deemed a waiver of any rights to bring that action in the Superior Court, but shall not abrogate any party's right to appeal the decision of the board to the Supreme Court.
In other words, we're just skipping the Superior Court.
Yep. And then if there's an appeal from there, it will go to the Supreme Court. But yes, it is diverting municipal housing appeals from the court and putting them before the board. The board shall retain jurisdiction of any matter originally brought before it. At any time during an appeal to the board, if the board determines that it does not have jurisdiction to hear the appeal, the appellant shall have 30 days to file an appeal with the Superior Court. In an appeal of a local decision on housing or housing development, any claim that is within the board's authority and that has previously been or is subsequently included in an appeal in Superior Court by another party to the decision or by any other aggrieved or injured party who can demonstrate legal standing to appeal shall automatically be stayed by the court to provide the party with standing the opportunity to intervene in the matter before the board.
Does this mean, as a practical matter, if somehow some other appellant, either because this wasn't law yet or whatever, it leaked around the appeals board, this appeals board, it just goes back to the appeals board?
It stays the proceeding. And so I think perhaps one example could be like if it's a mixed use development and someone has brought an issue to court regarding the commercial aspect of it, but someone has brought an issue regarding the housing part to the board. This is staying the appeal at the court. So putting that on pause.
And then it's up to the court, to this court, to decide
If they should intervene.
if they should take it.
Yeah.
If they do, then the Superior Court has to dismiss the action If they don't, it goes ahead in Superior Court, right?
Yes, that's on the next page. Yeah. Yep. Yeah, so if it's granted, the stay of the court action regarding those claims shall continue during the appeal to the board. After the board has decided its appeal, the court shall dismiss the matter before it to the extent that it has been resolved by the board. Any claim included in an appeal to the Superior Court that is not within the board's authority shall not be subject to automatic stay. Appeal shall be filed.
Can I ask you?
Oh.
I'm sorry. Can you just redefine for me, in case I missed it, what a stay is? Is that like we're not gonna hear this
It's a
yet?
pause.
We're
Yeah,
not gonna-
so
Okay,
that is some legal jargon. A stay is a pause. So something is going on or the court says, oh, we are staying this action right now until something else is resolved. So it is a pause.
okay.
Can I,
Yeah.
just clarification of the previous part there of your scenario of commercial versus housing parts being appealed. Can we run through that for a second, one more time?
Sure, it's probably not a great example, but because this is, so you definitely have the ability to make a decision here if you don't like how this is structured,
Yeah, I'm just
but
trying to understand how it is structured.
so if someone brings an appeal to the court,
Superior Court.
Superior Court,
Yeah.
the civil division, but then someone is bringing an appeal on a housing issue to the board, the court will say, oh, something is happening at the board. These two things are related. We're gonna pause this. And if the board resolves this issue, we will dismiss this case. But potentially,
Board can't resolve that case.
yes. And so then that's why it's a pause.
So the board,
So they're gonna put it on pause because they might solve an issue that they not even allowed to solve.
yeah,
Yeah.
what, it gives the
Well-
power to the board
So there's an,
to decide whether something that's started in the Superior Court, should it be resolved by the board or should it be left to the Superior Court? And the board can decide either way. If the board decides, no, this really relates to our hearing and we want to decide it, that's it. The Superior Court has to drop the case.
and there just may be some gray area on projects that are more than just, a single house. There may be projects that are a little more complicated and involve things that are both housing and not housing. But also this is based on the New Hampshire structure and it is, there's opportunity here for you to clarify things that might not make sense for Vermont.
But it's all part of, I understand this, what they're doing is they're creating a body and they're wanting to make sure that cases go to it and not somewhere else.
Yeah.
And this is just one variation on that. Yeah.
So down on line 7, appeals shall be filed with the board within 30 days following the final decision of the appropriate municipal panel. At the same time an appeal is filed with the board, the applicant shall notify the appropriate municipal panel of the appeal. So they have to give notice to both the court, to the board that they're filing and to the municipality. The appropriate municipal panel shall within 30 days following receipt of notice of appeal, submit to the board a certified record of its proceedings on the matter subject to the appeal. So not all towns, actually most towns in Vermont do not have certified records of their hearings on municipal permits. And so it is a slightly more formal process. Currently, the environmental division of the Superior Court, when it hears appeals, it hears them de novo because it is not following the strict formal requirement of on the record hearings. So this is something that potentially would require towns to be more formal at their permit level. And so you may want to consider that.
Do most towns record their sessions?
They may now, but I think it's less than 10 towns have formal on the record hearings for municipal permits.
Do you mean an on the record hearing can be done with a court reporter, which most towns don't have.
Right.
In fact, almost no town
Right.
has someone actually doing it, or it can be recorded either by video or otherwise. Do you know how, so when you say a very small number of towns have on the record, what are you referring to?
The former in that sense.
The court reporter,
Yeah.
of course.
Yeah.
They're not gonna, it's very
Yes.
expensive. If there's a video recording, does it have to be transcribed?
I don't know. That would be something to learn more about.
Is the intention here?
I think the intention is that it is not a de novo.
That's what I was gonna
Yeah.
ask.
I don't think it's a
It's
de novo.
not a de novo hearing.
Yeah.
It is on the record. For you, would you like to explain to the committee and the audience what the difference is? Because that is probably the single most important aspect of this.
Yes, so currently the environmental division hears its land use appeals de novo. So both Act 250 and most municipal permits are de novo, which means they hear the case anew, fully anew. So even though at the permit stage, they put on this evidence and say, this is why I qualify for the permit. When they go to the appeal stage, they present all that once again. It's very little deference to the body that issued the permit. The court is standing in and finding the facts and the legal requirements of the case. And so on the record review is a much narrower review with less deference, with more deference to the permitting body and what they decided. And so it's looking at the legal issues and if the body followed them correctly.
Is there a standard in this bill?
There might be.
Usually, when something's on the
Yes, there
record,
is.
where is it?
It's on the next page. It's in subdivision I on page 7.
Persuaded by the balance of probabilities, the evidence before it that is this really Vermont language?
No, it's not. This is New Hampshire. So this is a reasonableness standard.
Yeah.
Yeah.
Usually, my experience is either they could decide it. So it's de novo, but it's not deferential. In other words, forgive me for,
I know this is like a big deal nerd
Like,
conversation.
you can't be arguing against
But
it
this
for a
is- this
policy
is-
reason.
this
It's
is
really,
very important. This is,
Yeah.
it goes to the guts of what this court would do. And I'm not taking any, of course, position on it, but one approach is to say it's de novo. That means if the developer testified before the select board and if opponents testified, that's fine, but they're gonna have to go testify again. And in fact, whatever they said before the select board is irrelevant. What matters is what they say before this court. That's de novo. That is not what this bill does, right?
Right.
What this bill does is say there's a record. That's all we can look at. That's a little ambiguous because it provides for witnesses. When a hearing's on the record, there are no witnesses. Right?
I do not have a ton of familiarity because there's so few that happen in Vermont. So yeah.
My experience is you go one way or the other.
Yeah.
Either it's on the record, the court looks at the transcript, or they watch the video, or they listen to the recording, and on that. Then the question is, okay, they've done all of that. What is the standard that they should use to make their decision? One standard is kind of not very differential to what happened below, which is to say, well, we decide whether we think it's reasonable, what they did is reasonable. Another very common standard on the record, in fact, I think the most common, is to say, we can only overrule the town if they made a major and important procedural error, like didn't give a hearing or whatever, or B, they abused their discretion. It's very deferential to the underlying body. That's how most hearings on the record that are not de novo, they go one way or the other. That's my experience. This seems to me to be very ambiguous. Okay,
you could-
I might express it. I think it would need, let's put it this way, don't you think, council, that this would require a good bit of work
Yes.
to make it Vermonty?
It does need work. There is language that needs to be changed to conform to Vermont.
Okay, go on, I'm sorry, I interrupted you. Now,
No,
that's-
and
There's reasonable and then there's Vermont reasonable.
well, and I will say there are differences in the way that I think New Hampshire towns administer their
Sure, of
zoning.
course, yeah.
And so that may not fully translate even in that way
Right.
to Vermont
Okay.
town zoning. And so, yes, last year, I rewatched the testimony from last year. Judge Zoning came in and had lots of points about how the judiciary would need additional information in order to like make sure that they were working within the confines of the
Okay.
structure. So back on page 6, so they have 30 days to file and then 30 days for the appropriate municipal panel to turn over their record. The board shall then serve notice in writing of the time, place, and cause of any hearing upon all parties at least 20 days prior to the hearing. They shall hold a hearing on the merits within 90 days following the receipt of the notice of appeal. So this is one of the other big things in here. You can set clear timelines because this is not an entity that's part of the judiciary. This is going to be a creature of statute. So you have a lot more ability to set the parameters they will operate under, including all these timelines.
You're now at 5 months,
Yes.
30 days.
30 days, 30
to
days.
certify, 30 days to notice the hearing, then the hearing,
Mhm.
and then 90 days to decide.
Yes.
So that's
To hold
not
90,
counting.
so 90 days to hold the hearing, and then they have to issue a decision within 60 days after conducting the hearing.
So that's
7-ish months,
3, 4, 5 months to get to a hearing, the hearing, and then how long?
60 days.
So
Within
we're at
60.
7 plus that, whatever, 7 months plus whatever the hearing. Okay, thank you.
Appeals shall be consistent with the Superior Court. Appeals shall be on the certified record, except in such cases as justice may warrant. Onto page 7, in the sole discretion of the board, no additional evidence will be introduced. The rules of evidence shall not strictly apply. The board shall record the proceedings of any hearing before it and shall make such recordings available to the public for inspection and recording from the date of the hearing to a date that is 15 working days after the board has made a final decision on the matter that is the subject of the hearing, or if an appeal is made from such decision, the date upon which the matter is fully adjudicated, whichever day is later. So they have to publish the recording of their hearings. The rules of evidence not strictly applying. This is interesting. The courts obviously apply the rules of evidence strictly. So that is different, but this just gives them some flexibility on how they will handle that.
This is also very important. Lots of appeals.
Have a lot of
A
motion.
lot of, for example, a state that has an air resources board that decides whether something needs an air quality permit. And then it may have a hearing board that hears appeals of a permit denial or appeals by a citizen of a permit grant. And the hearing board will have, typically like this one, will have engineers on it and a lawyer, but engineers, et cetera. And when it takes testimony, it doesn't have to follow the strict rules of evidence. For example, it can hear people say, well, so-and-so, hearsay evidence. So-and-so told me this, so-and-so told me that. And the trier of fact, the board can just decide, do we want to listen to this? How reliable is it? But there's all the rules of evidence aren't necessarily followed. That's what this sounds like.
Yeah.
The
And
more this goes on, the more it sounds to me like de novo. If there's hearings, there's witnesses, there's
flexibility. Yeah.
flexibility, this is de novo.
It seems almost like a hybrid, and so there was an intent here to streamline the process from the court system. I think so, like it's supposed to move faster, but also empower these 3 members to make decisions more quickly than a court would. So then subdivision I, we did talk about briefly. So the board shall not reverse or modify a decision except for errors of law, or if the board is persuaded by the balance of probabilities, and so we think of this as greater than 50% chance that on the evidence before it, that the decision was unreasonable.
That the decision, okay, I'm not even gonna get started. That they decide in the exercise of their reasonable discretion, whether the action of the body below was unreasonable, right?
Yes.
Okay, thank you, counsel.
It's interesting to have another attorney on the committee. There's a little back and forth we're having. So non-attorneys.
I'm just trying to keep.
No, I
you-
know.
keep you- and you-
It's good.
interested, you know?
So non-attorneys, including professional engineers, architects, and land surveyors, may represent any party before the board. Nothing in this section shall prevent the board from denying representation by an individual it deems to be improper, inappropriate, or unable to adequately represent the interest of the applicant. So again, this is part of the less formal than a court proceeding would be. The board's deliberative processes in adjudicatory proceedings shall be exempt from the public meeting and notice provisions of the open meeting law. Decisions and orders in adjudicatory proceedings shall be publicly available, but only after they have been reduced to writing, signed by the quorum of the board and served upon the parties, and shall set forth the board's rulings of, onto page 8, law and findings of fact in support of its decision. Discussions and actions by the board concerning procedural, administrative, legal, and internal matters shall be exempt from the meetings and notice requirements of the open meeting law. And that makes sense because the judiciary is largely exempt from the open meeting law requirements. Rules, the board shall adopt rules pursuant to the Administrative Procedure Act necessary for carrying out its functions, including rules of procedure to be followed in the hearings conducted by consistent with provisions of this chapter. Appeals to the Supreme Court. Decisions of the board may be appealed to the Supreme Court by any party in accordance with 10 VSA 8505. Enforcement. After decision of the board becomes,
What is that?
it's on the next page, I believe. So that's just it's on page 10. So it's adding that the appeals of the board can go to the Supreme Court, and that is their,
How many days?
I believe it's 30. Yes, it's 30 days, and that language is on page 10, but so it's adding the cross-reference so that the language matches.
Correct, by the way, that the court has to reach a decision within a certain time, correct?
The board?
Board.
Yes. Yep.
But then there's no time limit on how long they take to prepare their findings of fact and conclusions of law. And until that's done, there can't be an appeal, is that right?
So they have to,
They just have to announce a decision. Normal, all I'm saying is, yeah, and it's silent on that, right?
sure,
Yeah.
yes.
By the
So
way,
that
what
could
we're
be
talking
clarified.
about is normally, you can't, this court, this environmental court, the judge may hear the case or the panel and just say, we rule for the applicant. That's a decision. Then they would ordinarily, in a normal court, turn around and say to the lawyer or the representative of the applicant, please prepare findings of fact and conclusions of law for me. And they write up the decision. Somebody writes up the decision, gives it to the judge passes it around all the parties, listens to them, and then issues their written decision of finding of fact and conclusions of law. And that can be a rather that actually can be a process that consumes time. And I think this is silent on that.
And is that to sort of develop a precedent?
Yeah, it's to
That's
develop
right,
the
like,
record,
You've got to be
the
very
real,
careful.
yeah,
how
that's
you-
what's
What
appealed.
you write
Yeah,
down,
you gotta be
because your
careful,
decisions.
because that's what's appealed, yes. And I suspect this is ambiguous on how that works, yeah.
Yeah, that could be clarified. So back on page 8, there's enforcement. So, after the decision of the board becomes final, the board shall, at the request of any party, file a certified abstract in the Superior Court. The clerk of the court shall enter judgment, and such judgment may be enforced as with any final judgment of the Superior Court. Neglect or failure on the part of the municipality to comply with such orders shall be deemed willful neglect of duty, and it shall be subject to the penalties and damages provided by law in such cases. All right, so then section 2 amends the language, sections 2 and 3 amend the language for the court. So 10 VSA 8503 is the environmental division of the court. So on page 9, this chapter shall govern all appeals arising under 24 VSA chapter 117, the planning and zoning chapter, except for those appeals brought to the Housing Board of Appeals pursuant to this language. Section 3 is again about the environmental division. So on page 10, it adds language that there shall be no appeal from an appropriate municipal panel when the appellant brings the appeal to the Housing Board, a Board of Appeals established in 24 VSA chapter 116. And then again, section 4 is about the Supreme Court. And so any person aggrieved by a decision of the environmental division pursuant to this subchapter, any party by right, the board, or any person aggrieved by a decision of the Housing Board of Appeals may appeal to the Supreme Court within 30 days following the date of the entry of the order or judgment appealed from, provided that the person was a party of the proceeding before the Environmental Division or the Housing Board of Appeals. And then finally on page 11, again, it's adding on line 4 reference to the Housing Board of Appeals. And then section 5 adds the positions and appropriations. So full 3-time board members are created and 1 staff attorney. This was me just sort of taking a swing at it. You may want them to have additional staff, but 3 full-time board members paid at the rate of a Superior Court judge comes out to about $500,000. And so, and then with 1 staff attorney, that's a $600,000 appropriation, but they are also going to need offices and supplies. So it would probably need to be more than $600,000.
700,000, yeah.
Yeah. And then the Supreme Court shall appoint the members for the Housing Board of Appeals on or before July 1, 2026. And again, that's a really short sentence, but because the Supreme Court currently doesn't have a procedure for going about appointing people. So you would probably need to build in some extra language about how they would go about searching for the candidates and appointing them.
Any further questions of our council by members of the committee? Oh, I have 1 question of the
Sure.
council.
Yeah.
Just 1. There is an outstanding charge to the Land Use Review Board
Mhm.
to study appeals, which may or may not implicate this particular legislation. I would inquire of you whether that report is due January 15th.
It might be
Or
February.
February
Yeah.
of 2026.
Yep.
My concern is that whatever entirely aside from this bill, whatever in that bill is going to deserve attention by the legislature. And if we're going to give it attention, that date is too late. That means that even now, as we are worried about the approach of town meeting week, even now, we don't have, imagine that report wouldn't even land on our desk for another 4 days if it was on time. And so my suggestion was to you that the report be due November 1. This is particularly important because in the second, particularly for the new committee members, in the second, you know how in the second year of the biennium, Ledge Council has a deadline by which bill requests must be submitted, which is December 1. So if we want to actually do something, I figure we need it by November 1. Have you had any communication with the board staff?
I did.
And I know it's hearsay testimony, but do you wish to tell us whether or not their view is, or shall we have them in?
You probably should have them in. I mean, I did give the heads up that you had that exact concern, and I think they will make an effort, but it's still pretty early in their process. So, my only other thing is, I would say is that you would potentially have the ability to do a committee bill. That is a later deadline.
Yes, I know that.
So
Yes, and I bet it's early in their process because
they just,
if I had a report that wasn't due till February in 2026, it would be early in my process. And
right, well, and the board started 3 weeks ago. So they, but they did, I believe they've been assigning they've assigned each member a task to sort of lead, and they have started looking at it. So,
great. Any further questions? Thank you so much.
yeah.
I really appreciate your testimony a lot. This was great.
I do have one question.
Oh, Joe, shoot.
Sorry, really. I tried to follow it. I got to the 7-month point with you. What is the full length of the before you're in front of the Supreme Court? Because then there's going to be a
It'd be probably
file to appeal it,
8, 9.
and you have to get your time with this.
So, I am not a trial attorney, and so the distinction that the chair pointed out about entry order and issuing of the decision, I had not really considered. And I don't know in practice how that would work for them. You could clarify for them that the 60 days from the hearing. So it's after a permit has been issued, 30 days, they have until 30 days to request an appeal at the board. And then the board has 90 days from that to hold a hearing. And then from 60 days, they have to issue a decision. And so I do think that you could clarify that timeline slightly about the last deadline. But here's some hearsay. I have heard that New Hampshire likes the model they've set up because they didn't need to wait 90 days initially to hold a hearing because it was a brand new process. And so they didn't have a line. And so someone could request a hearing and they'd say, oh, can you do it next month? Because they don't have anything else going on. So because this is a new board that doesn't have a docket already established with other people waiting, it could potentially move sooner than a 7-month window.
But if it didn't,
But if it didn't,
just in terms of deadlines, it's 1 month to file an appeal, 1 month to prepare a record.
yes, but it does say that the court has to hold its hearing with it. The board has to hold its hearing within 90 days of it being filed.
Of it being filed.
Of it being
Okay,
filed.
so 1 month to file,
30 days.
3 months to hold a hearing, so that's 4 months.
Yeah,
And issue a decision within
60 days.
2 months, so that's 6 months
Yes.
to a decision.
Yeah.
And forgetting about my wrinkle about the record and all, so
Yeah.
that's 6 months.
Conceivably, yes, it's 6 months.
And then it goes to the Supreme Court, 30 days, 7 months. And then the Supreme Court, however long they take.
And not everything does get appealed to the Supreme Court. So,
Yeah, I'm just curious.
yeah,
Great,
yes.
thank you so much.
Can I actually ask a quick question?
Go ahead, please.
So compared, so we're talking about however many months compared to what today?
It's a little over a year, I believe, on average to get to the environmental court. And then
To get through the
get
environment.
through, yes. So they have their statistics on how long on average their cases take, but I believe it's a little over a year.
And that's partly because of backlog,
Yes.
And it sounds like they listen to everything de novo.
right? They
Yep.
listen to everything de novo. This court would be backlogged pretty quickly as well. I mean, it may be new for a year, but then it's backlogged. Yeah. So everything, the ability to make this process faster would depend on the standard of review. Is it de novo or not? In Vermont, is it possible to not be de novo if towns don't record? You know, you can't have a deferential standard of review and a review on the record if there's no way to produce a
Yeah.
record.
You've got to have some trust
Right,
that you're gonna be
yeah.
deferential.
Well, or else if it was really a lot faster, then people who were project proponents would have to make a decision to pay a court reporter to sit during the testimony and record it.
And the court would also be in the position to give you sort of the statistics on how the universe of appeals we're talking about. I don't know off the top of my head what how many housing municipal permit appeals there are every year to the environmental division. But it is part of the other appeals they hear. So it's one of the different types of appeals that they hear.
Thank you. Members of the committee, we have our next witness, Steve Dolgan, who is testifying in his capacity, not as being the, shall I say, lesser half of one of our candidates, but as a landlord. But my question of the committee first is, do you guys want a break now, or do you want to go right to his testimony? Good. People okay?
Yeah.
All right, Steve, welcome. Why don't we have the committee, can you see us?
I
Can you
can,
hear us?
yes.
Yes. Can you, I'll tell you what, we're gonna have the committee introduce itself to you, okay?
Hi, Steve. I'm Ashley Bartley from Fairfax in Georgia.
Hi, Steve Leonora Dodge from Essex Town in the city of Essex Junction.
Joe Parsons, Newbury, Topsom, and Groton.
Hi, Tom Charlton, Athens, Chester, Grafton, and Wyndham.
Debbie Dolgan from St. J, Concord and Kirby, and anyone that's zooming on, yes, this is my husband.
Good morning, Mary Howard, Rutland City, District 6.
Good morning, I'm Elizabeth Burrows, and I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
And I'm Mark Mahaly, and I represent Calais, Plainfield, and Marshfield. And why don't you state your name for the record and then take it away? I will tell committee members that Steve has provided, I think, several documents or photographs, and that those are on the committee website. I don't know, Steve, whether you want us to be looking at those ourselves or whether you want to share your screen and show them to us. You have either option.
Thank you very much. I appreciate meeting with every one of you guys today, and and again, I really thank you for taking the time. What I'll do is I've got this written out, and again, it's I'm sure there'll be questions, and I'm prepared to hopefully answer anything you may have. I'd like to start out by thanking the Housing Committee for letting me present my thoughts on a few items. Here's a tad about me. I live in St. Johnsbury and have been a landlord for over 50 years. Right now, I have about 40 apartments within 11 buildings. I am like the go-to person for many area landlords who have all kinds of questions. In fact, I'm mentoring two much younger, very business-savvy individuals who now have a combined 18 apartments and are looking for more. In my career, I have seen about everything involving tenant-landlord relations. I will break this down to show the committee what really goes on through my landlord eyes in an eviction process and the related effects. And this topic is only involving the non-payment process that the law is now in effect. Please keep in mind that this is a huge step to address to increase the likelihood of much more private funding for housing. How you say? Well, here's my answer. We must drastically shorten the time it takes to evict the non-paying tenants from our apartments. Mind you, we landlords have zero desire to have to evict anyone for non-payment of rent. But when a tenant falls behind, usually the landlord is the last to know, only finding out when the rent does not get paid. We would then immediately open a dialogue with hopes that it is remediated very quickly. 80 to 90% of the time, each day that the rent is late, the tenant-landlord relationship gets worse. And it always becomes the landlord's fault because we're the one that sent the notice to quit for non-payment of rent. Here lies issue number one for me. It is absolutely ridiculous the time it can take to evict a tenant under the non-payment part of the law. Keep in mind that we have many, many amazing tenants, and this just deals with the troublesome ones involving non-payment. So here's a very common non-payment of rent scenario. First of all, we must send a notice to quit which must be a minimum of 14 days and up. By the way, and I'm not sure how many of the committee would know this, but almost no landlord knows about the Federal CARES Act, which was never sunsetted after COVID. The CARES Act increases the notice to quit to 30 days. There is a list of these qualifications that the tenant and landlord must meet. This act needs to go away fast, but that's on the federal level.
Yes, Steve, does that apply to all tenants or only certain tenants?
That applies to the tenants that would qualify. For example, under the CARES Act today, let's say that the house itself is financed through VHFA or something at your mortgage, you have a mortgage. Well, what that does, that protects everybody in that particular apartment building from the 14-day eviction notice. You have to give them a minimum 30 days. And that doesn't matter, again, depending, it applies to the entire home, not just the tenant that moves in. So there's a lot of qualifications there that, and the problem that you have when you get to that level, because again, many people don't know about that. If you were to go to the courts, the first thing they'll throw that case out, and you got to start all over because you failed to give proper notice. Let me just see. Okay, let me just see. By the way, the Federal CARES Act. Please keep in mind that the landlord will be responsible for any and all code-related repairs that the tenant could cause damage even while still occupying the unit. I have included a few pictures that we'll talk about in a minute of what a very nice, at least the reception time apartment, looks like the day the sheriff removes the tenant. Once the tenant receives a notice to quit, the dark side can start. I would say that about 85% of my past cases, tenants start to teach us a lesson by doing a wide range of misbehaviors. These include violating the terms of the lease further by bringing in more people to stay, partying late in the mornings, bringing in more pets, breaking things like punching holes in the doors, smashing cabinets. They drag stuff across the floors, ripping the flooring. For some reason, they seem to keep all their household rubbish inside the apartments. By the time the landlord can hire an attorney and actually file the eviction lawsuit at the end of the notice to quit, and a date is set, can now take 3 months more just to hold the first hearing, which is most of the time a motion to pay rent into court. The actual hearing on the merits could be scheduled 2 months later. And then if the landlord should prevail and have the court issue a writ of possession, another 2 or 3 weeks can easily go by until the sheriff can do a physical eviction. So you, the landlord, in the meantime, must pay your mortgage, taxes, insurance, water, sewer, and maintenance, and pay anywhere from $2,000 and up for attorneys, plus costs and sheriff's fees. What about the other tenants in the building? They become extremely upset that their neighbor now has all these extra benefits that they don't have. They constantly call me to complain about the extra noise, cars showing up all hours, and demand I stop this at once. These tenants seem to know that they are in control of your apartment and they have rights that will allow them to stay for long periods, rent-free. And they seem to teach their children the same methods of how to rent free in Vermont. I have had more than one third generation related tenant that I've had to deal with the same issues as their grandparents. Oh, and I haven't talked about the damages that seem to occur with most every case that we have. Now that the tenant is gone, I must deal with removing all the possessions, filth, and garbage left behind both inside and outside the apartment. Then I must start repairing all the damages that I could not address while the tenant was occupying the unit. How about a wintertime eviction? Now I must pay for the electricity and heat while repairs are happening. So now add in another month's lost rent, and now you have over 7 months of zero income. You've paid all the upkeep, eviction costs, and easily $5,000 to $10,000 in costs of the repairs. You can see that the above process could take 7 months or more to solve this concern. I asked each one in this room to tell me how you would be able to survive financially or even mentally during this huge time frame the laws now allow for non-payment of rent in Vermont. This conversation has and continues to happen all across the state. I have known many smaller landlords desperately trying to offload their rentals once they experience the non-payment category I just described. It's over for them. It's absolutely time for this to change, and change hopefully this session. I ask that this committee draft something, anything to drastically shorten this process. Look at other states, as you certainly do not need to reinvent this process. Louisiana has the shortest eviction process in the country. Landlords only need to send a 5-day notice for things like non-payment of rent and lease violations. The whole eviction process can be wrapped up in just 2 to 5 weeks. Bottom line, with the current eviction for non-payment of rent laws, you can clearly see why many smaller landlords are bailing. If we could pass new laws even close to Louisiana's timeframe, we would immediately find that any of these potential new and habitually old tenants in the non-payment of rent class would realize that they would need to actually pay rent and on time, as they would quickly realize they face being evicted extremely fast. And what about our landlords in Vermont? Knowing that they would not spend foolish amounts on this type of evictions would open up a whole new world for them. They would now know that they have legal protection and absolutely look for more units to acquire, as I would. I would ask, what harm would it be to become like Louisiana? It would be a win-win for all landlords, keeping investment funds in their pockets and removing a tremendous amount of negative stress. We landlords would easily work to lower our qualifications to rent to any potential tenants, as our risks would drop tremendously. All the above would increase the bottom line of equity as well. We can open many doors for private financing equity to purchase blighted properties, reinvest in our current inventories, and develop smaller housing projects. No doubt we need a good mix for the for-profits and the larger non-for-profits to jump into the mix. My own small company, as I speak today, is working on 5 separate projects, bringing 5 new units to the rental market over the next 6 to 9 months, all with private funds using cash flows, mostly with some local bank support. Most every town has blighted properties. They would now be looked at as a profit center, and landlords, just like the 2 guys I spoke above, would certainly grab these up. These law changes will certainly spur much needed housing again, especially for the small landlords that are dealing with the above concerns. I don't know, I was going to move into something else. Do you have any questions at this time?
Questions by the committee? Steve?
Yes.
Any questions by the committee? Can I zoom in on one of the stages that you referenced, and that's the stage once you have a judgment of whatever the judgment's called, eviction or whatever, then what happens then, and what is the time frame, but the various time frames and steps that lead you to the moment when the sheriff is, I guess, locking people out or whatever, the actual possession?
So the time frame by law is, I'm going to state, once you have to go to court again, and the court would issue a writ of possession, what happens? The sheriff has to go serve the tenant, and I believe it's within about a 14-day period, and that depends on a few facts as well. But it could take by the time all the paper gets done, everything happens, it could take another minimum 2 to 3 weeks to have a physical eviction.
Do sheriffs, are they backlogged, or do they, once you give them the paperwork, do they act pretty quickly?
They're very good. They are really do. They're very cooperative. Yes.
Okay, and then what do they do?
As far as when an eviction takes place,
Yeah, I mean, they serve the tenant, then what?
they'll serve the tenant. They'll do they always appear to do a lot of counseling and to advise the tenant this is real, and that you need to be gone. We'll be here physically. And unfortunately that happens many times. The tenant is there. There is a picture that I have on the wall that shows it's a kitchen. And that is the actual day of an eviction that happened in St. John's Center. I took that picture. And there's a picture of a
That's the one
kitchen.
that's down, yeah, that for members of the committee, Ashley, thank you. That picture, Steve, is not on our website anymore. It's not accessible to us because it had pictures of individuals and we can't do that.
Oh,
What is there is the picture of all the needles.
okay, well,
But anyway, so the sheriff is, when they serve the tenant, are there a certain number of days that have to elapse before they can actually carry out an eviction?
yes, there is.
Okay. And then they come and remove the tenant.
That is correct, physically, if necessary.
Thank you.
So,
Question, yeah,
Oh, I'm
go
sorry.
ahead.
No, go ahead.
Oh, thank you. So I know that this is, maybe not a fair question because you're one landlord, but, do you have a sense of, kind of the proportion of evictions that end up that end up in this situation as opposed to, compared to all of the evictions that end up happening, statewide? Like, we're seeing some really worst case scenarios, which are, this is very troubling that this happens. And obviously is not where we want to put, our VHFA dollars, and we don't want to discourage people from renting. So do you have a sense of how many times sheriffs have to get involved with evictions, and this kind of situation?
As opposed to people who just self-evict when you notify.
Self-evict or just leave on their, leave when asked to make the deadline?
I would say that we're talking a minimum of at least 33%, probably, where it does go to a physical eviction. It's a high number. I mean, we're constantly trying to negotiate. We're constantly trying to, have this tenant leave. However, again, as I mentioned, what happens probably 80-90% of the time is we have a ton of damages that have been caused, tons, and that just it tears the heart of a landlord right out.
So you think it's, in your own experience, that
Yeah.
it's common that there's damage?
Oh,
to apartment?
definitely, most definitely.
I'm shocked to hear that figure, just because I don't know how we have landlords at all then in the state, if a third of your apartments are being torn up and people are not paying rent. That seems.
Let me clarify. It's not a third of the apartments. It's at the level when you're going to court, where we're going to the final eviction. About a third of them will continue all the way through.
So he's not saying a third of all tenants.
Right.
And 1/3 of all evictions.
Got it.
Right. We've got some very, very, very good tenants, and as I mentioned, we're not interested. No landlord wants to evict anybody if there's any issues. Trust me, that's not what we want.
Right. So you're saying when there is an issue and you're issuing an eviction. And are these evictions that are within the lease term, or are these like at the end of the lease? Like, okay, your lease is up and we would like you out.
And these are always, in this case here, non-payment of rent that'll happen during the lease period.
Okay.
Please go ahead, Elizabeth.
Thank you. So you said you had around, I think you said 50 units. Is that right?
Around 40, yes.
40, sorry. Many of your tenants are long-term tenants? Like,
Oh, yes, I have some almost 30 years.
okay, and in general, would you say that the tenants that we're talking about here are, I mean, does this ever happen to long-term tenants? Or are they shorter-term tenants?
Definitely shorter-term tenants.
Shorter as in 1 year or 5 years, or?
It would be under a year. Usually when you have an issue, it's going to happen within, 4 to 6 months.
And what kind of background check do you do on your tenants when you take somebody on?
So I try to do I try to do a background check with the previous landlords, some employment references, things like this. That's what I do. I've spent my life taking a lot of risks, working with, less privileged or something like that. And I got to be honest with you, my record is not good. It's actually pretty bad. Trying to help out.
Well, one of my questions that I've talked about before, one of my concerns about setting up a very foreshortened eviction is for people like people who are regular long-term renters who get sick and lose their job and have circumstances that would be very much exacerbated by being evicted. And I'm not saying that you're a cold-hearted landlord, I'm just saying that setting up a law straight across the board where all tenants who have non-payment, you would have to, you could not make exceptions. I suppose we could create a scenario where exceptions could be made, but I'm worried about people who are really facing personal turmoil, not of their own doing. And that gets compounded by, a kind of waterfall of circumstances.
We definitely run into that situation numerous times, and excuse me, and we always are trying to work it out. When you've got somebody who's had a personal situations cause them loss of income, there can be a lot of support through other agencies. We're not just a landlord in that case. We become, a financial crisis manager. There's a lot of resources that I know as a landlord, and we're always looking to try to help. So, I think that I would speak for, again, many landlords in that case. We're not interested in putting people out. That's not the situation. We're just, this conversation here at this point really is involving dealing with the people that just don't pay their rent for whatever reason. It doesn't matter, and the dark sides that go with it.
And I understand that. I hope you understand that I'm not accusing you of being that kind of landlord. I'm just asking you what you think, what exceptions you think should be made in that kind of scenario, so that so the law doesn't sweep everybody who has non-payment of rent out the door, even if they have extraneous circumstances.
Steve, I should clarify that as we struggle to think of solutions to this, one of the ways of sort of seeking a more just system that works for everyone is to try to differentiate, either in terms of how fast people have to get out, or in terms of maybe the ability to receive help from the outside, between the renter you characterized, which is sort of not a responsible person, and the renter who's been there a long time and just for circumstances beyond their control, they can't pay. And you said something really important that I heard, and I don't want to put you on the spot, Steve, so just feel free to say, I don't know, or whatever, but it seemed to me you were saying, if I'm going to have the kind of trouble I just described earlier, I'm going to know it in the first 6 months. That's when the bad things happen. Is that true? Is that a reasonable period, or is it you get a lot of trouble with people who've been there 2 years?
No, it's definitely within that 6 month time frame. Again, you've got relationships you're building with people that have been there for a year or 2 years or 3 years, and they're usually very, they might be upfront. Most of the time they are upfront. They'll tell you, hey, listen, I got, my son got this, or I had something with my truck or whatever, and they're always trying. We try to work things out. That's not an issue.
So that's very helpful. Other questions by So you have more.
Yeah.
Follow up.
I should disclose that I have a cousin who lives in St. Johnsbury and is a landlord and has had and she only has one unit. She has had a hellacious time getting out a tenant who has been in her unit for 5 years and very suddenly became and I think it's been more than a year for her to try to get this tenant out through one really inane claim to the next. But my next question is that can you help me understand what I heard, and I just want some clarification. You somehow drew a line between evictions and buying up blighted properties, and I missed I was busy scribbling down, I missed the middle part. Can you explain that a little bit for me?
Well, as you can see right now, the costs affiliated with dealing with the dark side of these tenants and the time and the length that it's costing us as landlords. What's happening is if we can get this turned around and stopped, we need to stop the bleeding. Then it takes, you take a look at these other blighted properties right here in St. Johnsbury, and they become more valuable because we know that as landlords, we could invest in these properties and take a much better risk knowing that we've got the law on our side. Again, we're only dealing with the dark sides. We're not dealing with all the good people out there. And like, for example, I mentioned that I've taken 2 young guys in St. Johnsbury under my wing here, and they've got 18 apartments and they're looking for more. And they look to me for a lot of advice in this area here. And it's very easy. I mean, you know, if we can just stop the bleeding, we can put that money into the future and actually make money as a landlord. And that's where I'm saying that we can help on a lower level, absolutely, throughout the state by buying these blighted properties, because now we don't have that major risk of, as you can see, what I went through.
Are there any other questions that Steve might answer for members of the committee? Steve, this has been so helpful. Thank you very much. Really appreciate it. Yes.
Mark, can I finish? Can I bring up one more subject?
Please go ahead.
Thank you. Excuse me. One of the things I just wanted to bring out is this. I know this has been a discussion, and it's talking about the no-cause evictions. And we as landlords, and again, I'm only talking the dark sides here. You know, we really need to keep the no-cause evictions in place. And one of the pictures, at least if you'd like to take a look at, that you can show, I think, is the ones with all that I snapped. That's a 55-gallon bag full of needles that I found at one of our apartments. Now, there's no law in Vermont that I could evict this tenant under other than the no cause. I did not see that tenant put that stuff there. I just know that it wasn't there before I rented the apartment. But that's an example of reasons why we as landlords need to have that out on the no cause evictions. I can't stress how critical that is. It's not used all the time, but I can tell you where I have a tenant in St. Johnsbury, a young lady who has a couple of young children, and the tenant next door gave them a rough time about a hammer that he had lent. Well, there were some words took place, and they weren't very good. Now, there's no reason that I could evict this particular individual unless it has a no cause eviction. And that's exactly where we're headed. We're headed for court for no cause eviction because I can do that. I did not want to leave this 22-year-old lady, 2 apartments down from an individual that was hassling her. So, and again, I don't know if you guys are aware that unless that there's no state's attorney in Vermont that'll press charges against any tenant for anything unless there's a witness. And That's a real problem.
Is just to clarify, you're dealing with situations that are during the tenancy, right?
Correct.
But I mean, I understand there's a big problem with proof because people won't testify, et cetera. Put that aside for a minute. Isn't someone who's abusive or incredibly noisy or using drugs, aren't they violating the terms of the lease?
You have to, again, it all comes down to the proof part of it.
Right, okay.
And,
It's the
and
proof.
that's, yeah, and that takes everything off the table.
It's the proof problem,
Yes.
right? If it's at the end of the lease term, you would just evict them, right? That's not, or non-renew, right? This is to people during the lease term.
This is during the lease, correct.
Is there so the problem is proof and people not wanting to testify because they don't want to risk hurting themselves, getting hurt.
Well, it's more like, because we've certainly pushed the issue in our local community here. It's like, you know, a tenant moves into an apartment, you have a contract, and there's damages that may take place within the apartment. The you know, criminally, and again, I did talk, I mean, I had a little something here about the criminal part of it. Again, because the state's attorney says, unless there's somebody that saw that tenant do the damage, it's a civil complaint, and we are powerless. And that's what's creating a lot of the concerns that we're having with the no cause evictions. It's I mean, I'm just really asking you guys to figure out, you know, I know this is not easy. I get that. You know, been a landlord for over 50 years. I've seen everything, and I wish I could help you guys figure this out.
Any other questions of Steve? I think Steve, you've been really clear. I think your testimony has been excellent. Is there anything else either you want to say or members of the committee want to ask Steve before we break?
I have one more thing, if you don't. And
please go ahead.
Yeah, I've been involved in St. Johnsbury for many years, obviously with renovating apartments. And I just want to bring it to the attention of the committee that, you know, I really pride myself on cutting expenses and watching the dollars, obviously. And kind of like finally as an expense that I would like to have you discuss is the exorbitant costs being used to renovate current units by some of the nonprofits. These costs are 2 to 3 times what it should be costing. Yet there seems to be no oversight with this huge cash flow out the door. I just want to bring it to your attention that I'm not sure where to bring this up, but spending, you know, $300,000, $400,000, $500,000 to renovate a 2-bedroom apartment is absolutely off the charts. And you multiply that out, that's a lot of money going out the door that could be used for other very productive things.
Thank you. Any last questions? Steve, appreciate so much and stay well.
Thank you very much. I appreciate the
opportunity. Wait,
No,
Joe, do you have a question?
Just stand by.
Oh, wow.
Thank you for that. So very much appreciated.
All right, take care.
Yeah, thank you now.
All right, so members of the committee, we have until 1 p.m. And at 1 p.m. today, we are having 2 developers come in, testify. And these are people who could testify about their experience. One is from Summit Properties and one's from O'Brien Brothers. And they're going to testify at 1. So we should all be back here a little before 1. Also, I've talked to some of you, but I will be talking to each of you. We're beginning to slowly put together our committee bill. And our committee bill at the moment has a long list of issues. And I'm going to be asking each of you, I've talked to some of you to help with respect to some issue that's there. Because, I think it's really important that we all do the work a little bit, and Ashley and I can't do it all. So I'll be talking to each of you, and then the process will be we will begin to discuss a committee bill here. We'll be taking some of it's based partly on evidence that we've already heard, but we will be having people back to testify once we have a more concrete idea of what the committee bill will be. We'll be having witnesses in addition. Some of those are things that we haven't had a chance to have testimony on. There was recently one of the big, I'll give you an example, concerns right now is what about all the abandoned houses that are there? Okay. In Vermont, that is a major issue. There are a lot of abandoned houses. Steve actually referred to it when he was talking about, if you help us out, we'd have more money to invest, et cetera. There was a report that just came out 2 days ago on, or maybe end of last week, I'm not sure, which addressed abandoned housing in the form of the idea of using a state land bank, which could acquire the housing and then flip it. And
Is that on our website?
it's not, the report is not yet on our website. I just sent it to Magali. We could put it on the committee website. There's an example of where we've had no test, but it's an area of great concern. So we're going to get three people or so to come in and testify.
Wow.
So some of these things, we've had some testimony. We'll need more if we're really going to take it on. Some of it, we haven't had any testimony and we're going to have it in. Whatever we're going to do, we're getting started. So at any rate, it's 11:30 and we are, I think, about to be, I'm wondering if we're ready to depart.